Hi there, and welcome to our advertising law webinar from Venable LLP. This is Melissa Landau-Steinman. I'm so glad that you could join us this afternoon. We have a nice group. I am going to spend, I guess the goal is about 50 minutes talking about a number of topics related to loyalty programs. Hopefully we'll get into some fun here on this sort of cloudy afternoon here in Washington, D.C., and then we'll leave some time for questions at the end. You can submit them through the chat function, and then I'll try to get to them. If we can't, I'll get to them through emails afterwards. So in terms of, I'm still figuring out this platform a little bit, so forgive me if there are any technical bumps. In terms of CLE credit, this has been approved for CLE credit for 1 hour. So we will be distributing a code in the middle and at the end, and there will be a submission form sent out. So keep listening, and I'll be giving you that code as well. By way of introduction, loyalty programs, of course, are hugely popular. If you're not a member of at least one, I'd be surprised, and you should join because they're very valuable nowadays. According to an article published just this month in Forbes, more than 3.3 billion people participated in a loyalty program, and more than 90% of companies have some sort of loyalty program. Whether it's points or you earn a certain number of credits for each purchase, or you get coupons, every 5 buys, or a stamp on your card, but some sort of program where you earn free stuff based on your purchases or your visits to a location, something like that. Loyalty programs we all think about as involving contract law. Of course, you've got the program agreement and consumer protection law, but what people don't necessarily realize is the complexity involved. As over the years, loyalty programs have become more and more complex. They, depending on that complexity, can trigger a number of different areas of law, like fraud, of course. Everybody is trying to work some sort of scheme with their loyalty points online nowadays, but also unclaimed property, anti-money laundering and money transmission. We're seeing sweepstakes and contests. Privacy and data security is a big issue now with loyalty programs as well as everywhere else. Spam, TCPA, antitrust, labor and employment. So we're going to talk about a number of those today. So, of course, we start with drafting the terms and conditions. Incredibly important because that's, of course, where, you can find the protection if you ever get into trouble. In addition, you need to think first about things in the beginning is the end, things like your termination clause, the right to modify. That's where you see probably the most litigation is around that right to modify, that termination clause, and sort of hand in hand, the notification clause. So you can see a lot of the early litigation in particular, but also more recent, has been against the airlines, also the credit card companies, but involving this, what kind of rights do you have to modify those programs? Cases against US Air, Alaska Air, Continental, giving early on a lot of rights to the airlines to make modifications to their programs, to increase the number of miles, to increase how they measure distance, the right to change or eliminate frequent flyer program benefits, And pretty much the courts were saying, as long as the interpretations that were being given to the terms and conditions were reasonable, and the contract terms were drafted soundly, that the sponsors, if you will, of these programs were given a lot of rights to modify their programs, to terminate rights or eliminate benefits. Lately, you're seeing considerably more or considerably closer examination being given to these programs on consumer protection grounds, because you'd always see sort of one count or one claim on a breach of contract or some contract-related claim like promissory estoppel or that sort of thing, and then another claim related to consumer protection or claims. Early on, it was really all about the breach of contract. Most lawsuits were won on breach of contract. Now you see a lot more attention being given to those more consumer protection-oriented claims. Then we've also got, of course, in the era of COVID-19, we're going back again to our terms to look at terms like force majeure. Do you have the right to substitute rewards? Do you have the right to pull them all together or to postpone fulfillment, particularly with things like events, or travel? That clause in particular, as well as the modification clause, has been very closely examined. There have been whole webinars on the force majeure clause and what does it cover, particularly with respect to, force majeure clauses that don't specify pandemic or epidemic. And so, that's certainly something that I think insurance companies or reinsurance companies are going to be fighting for a long period of time. We're looking now at, this question of, can you modify the program terms and conditions to say, well, we're not going to provide some of these rewards, or a lot of the modifications actually have been very pro-consumer, to extend the amount of time you have to redeem, but in some cases there has been the need to substitute or to modify that force majeure clauses. So the question comes up, what kind of notice is required when you modify your loyalty program terms? Well, to start with, you should have some specificity in your program terms from the start as to what kind of notice you will provide if you modify your terms and conditions. How will you provide notice? How much notice will be provided? And how members will be accepting the changes. Generally speaking, most loyalty programs provide for little or no notice. 0 to 60 days is, a regular provision. In terms of acceptance, it'll say by participating, you accept the changes. We'll post them on our website. It's generally very pro-sponsor when you look at a lot of these program terms. The issue is that when you are very vague about the definition of notice, when you provide very little notice, you may find yourself, if you make a very, depending on the kind of changes you make, you may find yourself potentially at the wrong end of a lawsuit. Notice has become a key issue in some recent litigation. Case in point being a lawsuit brought against AutoZone about a change in its program where it took away the right to, or it changed how earnings and redemption of credits in its program worked. While it did not necessarily retroactively make changes, what it did was it made the amount of time that was permitted to redeem the credits that were earned in its program very, very short. The allegation in that lawsuit was that the time to redeem was so short that it effectively those credits became worthless based on the way that and the amount of time it took to earn and credits and redeem them in that industry, you know, in essentially auto parts and the way people earn and redeem when buying auto parts. Ultimately, like most lawsuits, that suit settled, but it is a good example of how you need to consider the facts when it comes to your program. How do people, what kind of change are we talking about? Is it a change that will take away some sort of right, that it will make it harder to earn points, that will expire points, or is it sort of a minor cleanup point? You know, to most members, changing the force majeure clause isn't going to really matter. So, you know, if you're changing, say, the value of points, you may want to, you know, provide some period for people to redeem the current points under the current regime, if you will. Whereas if it's, you know, more of a cleanup, you know, it may not matter how much notice you provide or, you know, how you provide that notice. You know, and sort of shooting individual emails out versus posting it on your website. All in all, of course, follow your procedures. Whatever you say in your terms that you will provide, you must do. So best practices, I kind of just went over this a bit, but you know, your notice should always be clear. You should explain what you're doing and when it's going to happen. You should not ideally impact any redemptions prior to the change date. And in terms of the timing of the notice, it shouldn't be too far out. You know, don't notify people necessarily 6 months in advance because people forget, or, you know, don't notify them the day before because it's not enough time. You might even want to think about multiple notices. You know, 2 months, then 30 days, then 14 days, and 7 days that, you know, gee, the way you earn your points is going to change, or please redeem now if you want to. And then, you know, whether you provide notice directly or posting online may depend based on the type of change we're talking about. It's a good idea to give advance notice of any change that will impact the value of a member's points, change the ability to earn or use points, of course, cancels or terminates the program, or converts the points over to a different program. So in terms of the UDAP or consumer protection laws, you know, we talked about contract, and of course the notice side of things sort of bleeds over then and leads us into consumer protection. Federal and state laws will prohibit any seller from engaging in unfair and deceptive trade practices, including promoting a loyalty program in a false and misleading manner, or failing to disclose material terms clearly and conspicuously, or failing to meet reasonable consumer expectations and assumptions. And I'm specifically laying those three out because that's what's come up in several Attorney General enforcement actions brought against drugstores in particular that you can see listed at the bottom of this slide. They got in trouble for failing to advertise their programs in a clear and non-misleading manner. For example, CVS, its advertising contradicted the terms of its programs. They and in fact internally contradicted itself. You know, they'd have one piece that said, you can earn up to 5,000 points for something, and another one that said something different. So you need to watch out in particular for conflicts between your advertising and your terms and conditions. You know, we talked about how traditionally the courts have relied on program terms to dismiss lawsuits and giving less weight to consumer protection claims, but that's changing. If you look at this case against JP Morgan, the court did find that a promise in advertising that points never expire could be deceptive. That was on a motion to dismiss, and sort of said, let's look at it on the facts. So it's a changing landscape. In terms of some of the more recent litigation that involves loyalty programs, some of the claims that we're seeing have looked at how points are accumulated or applied. So, you know, if you are applying loyalty points, you know, in conjunction with coupons or discounts at checkout, you need to apply them consistently and in conformity with your program terms. You know, make sure that if you are, you know, saying that you will apply points, you make them, they receive the full amount promised in the program terms. There have been some lawsuits lately alleging that, you know, they were I didn't get the full value of the points because I didn't get them back when I returned my shirt, and that was something that happened in a case involving the Gap. Or Kohl's was sued over its same as cash claim because points were applied before discounts in a transaction. They actually ultimately won on that claim because it was clearly stated in their terms and conditions how the points would be applied. So again, terms and conditions can do a lot here. As you can imagine, fraud can be a big problem with loyalty programs. This can be consumer fraud, you know, illegitimate accumulation of points, internal fraud where employees or insiders are, you know, work in the system, or external fraud in terms of hacking or identity fraud. So protections against fraud have to be designed into the program, whether it's clear rules, crafting them to prevent unintended point schemes, or educating program members to use strong passwords or change them, monitoring account activity, cybersecurity protocols and intrusion protection, or enhanced internal controls. But this is something that you need to protect against. Also, monitoring social media is something nowadays, but something to consider in designing your rules. Money transmission and AML, something that, because it's often we consumer protection attorneys that are involved in the designing the rules, we don't think about off the top, but the Bank Secrecy Act, state money transmission laws, and the like can apply, and generally you want to design your points program to ensure that that's not the case. These laws define money transmission as the receipt and or transmission of currency or funds or their value to another person or location. And the issue is that a currency can include convertible virtual currencies that have an equivalent value in or serve as a replacement for real currency. You want to avoid a situation where your points become a currency, where they can essentially be translated into cash. Some ways to do that and to be thoughtful about that are, A, obviously avoiding any situation where points can potentially be purchased or redeemed for cash. Looking out for a situation where you see a secondary market for points or credits. Another risky situation is where members are transferring points or credits to each other. And then also situations where there's purchasing of points. In any of those situations, you're going to potentially be triggering the AML laws, the money transmission laws, and you need to be thinking more carefully about program design and whether you're triggering those laws. Additionally, the unclaimed property laws have started to include provisions addressing currency and virtual currency. So we'll talk about that in a few minutes. The tax laws can also be triggered here. I will not profess to be a tax attorney, but I did want to note that. There are rules here that allow accrual method taxpayers to subtract points from gross receipts in an amount equal to the cost of redemptions in the tax year and estimated future redemptions, which will allow an accelerated recognition of redemption costs. There are certain requirements you have to meet here with regards to points awarded, the with sales requirement, and points awarded when making a purchase, and the redeemable requirement. So points must be redeemable for cash, merchandise, or other property. So most retailer customer loyalty programs will qualify under that regulation, but not all. The nice thing is it has to do with timing of the recognition, but that's sort of a very high level note, and then I imagine that probably most of the people attending the CLE are not involved from the tax side in any event. It's more a high level overview. Unclaimed property, on the other hand, seems to come up more and more in my practice, and we get this question with loyalty. The state unclaimed property laws, which are rooted in the common law of escheat, provide that certain property may be presumed abandoned under state law if there's no activity with respect to that property for a specified period. And so with regard to intangible property, like points or gift cards is another area where it comes up a lot. This becomes important, if somewhat complex and puzzling. So in recent years, state regulators have been very aggressive, and this is probably recent as in like the past 10 at this point, in seeking to collect this. And in particular, in sort of the advertising and promotions field, we've seen a lot with gift cards, which is an interesting area in that some states exempt gift cards from their unclaimed property laws and some don't. So under what are some priority rules set by the Supreme Court, you go through an analysis that looks essentially to whether you have the name and address of the purchaser or owner, and whether that state will escheat gift cards, and then whether the state where you as the issuer of a gift card escheats gift cards to determine whether you must escheat a gift card. I'm talking about gift cards because occasionally you will get a regulator who takes the position that points or credits that are issued as part of a loyalty program are in fact gift cards. And there are arguments to be made that that's not the case, but there's actually some ambiguity there. So it's important to sort of examine things and design your program to make it as clear as possible that that's not the case. In any event, the stakes here are pretty high, as you can see from this case cited here, involving Card Compliant. Card Compliant had set up what it considered to be a very clever scheme where various retailers could avoid escheat of gift cards, setting up shell companies, but the state of Delaware did not believe that that was as clever as Card Compliant thought it was, and went after both Card Compliant and the retailers involved. Ultimately, the retailer in this case was found guilty after a jury trial in a Reverse False Claims Act for concealing $3 million or just about in unpaid escheat claims. So unclaimed property can be expensive. With loyalty programs, however, we've got that ambiguity. And in addition, there are arguments that to the extent that people are not purchasing loyalty points, that there simply is not any sort of money involved. There's not any underlying value involved with the gift cards, or with rather the loyalty points. And therefore, under promotional and loyalty exception, in most states, that arguably loyalty points should not escheat. In addition, there's something called the derivative rights doctrine that also sort of has gives us a position that they should not. There's also some states that specifically exempt, a few that specifically exempt merchandise points, and others have created exceptions for loyalty cards. So there's various arguments here that loyalty points should not escheat, but there's a whole lot of mud and lack of clarity as well. So I'm going to give you your CLE code here, which is loyalty. So that's your first push of the CLE code. For sweepstakes and contests, increasingly we're seeing sweepstakes and loyalty, or sweepstakes and contests rather, being run as parts of loyalty programs. You know, win points or redeem your points to enter. And just to note that to the extent that you are requiring rewards points to buy entries, there's some ambiguity as to whether that would be consideration and whether you need to therefore offer a free alternative method of entry. You know, the question is, do points have value? You know, you use them you have to typically buy things or spend money to earn points, but points are often treated as being without value for tax or other purposes within the program. You know, you can redeem points for things that have value, like gift cards that have a specific money value. You know, you may be able within the program to bid with points as if they're money. Within the program, there may be a buy it now price in those auctions. So generally speaking, I think most programs will simply offer a free AMOE, alternative method of entry, to these sweepstakes where, you know, you have participation by you know, using points to participate as well. You know, whether it's that send in a card or, you know, 3x5 card or whatever it is. Charitable promotions are also increasingly popular, where you know, donate your points to the United Way as part of our partnership type of program. So, you know, what are the legal and practical issues there? Many of us are familiar with the traditional commercial co-venture, where, you know, you purchase something and a retailer gives $5 to the charity, which of course triggers some complex registration and bonding requirements in various states, along with advertising disclosures or possibly accounting and requirements as to what goes in the agreements. Well, here there's really no traditional purchase requirement. So, you know, we're talking about points. So are the CCV laws or the commercial co-venture laws triggered? You know, probably not. However, even where there's this kind of free action, which we may also see where, you know, you have post or tweet, and we'll donate. But even with this kind of promotion, you still want to do your due diligence about your charity partner. Make sure that they are registered to conduct fundraising. You still ideally want to have some kind of agreement with the charity. Make sure that you have a license to use their trademark. And you still want to be specific about, A, who the charity is, you know, what will be donated and when, what happens if the triggers are not met, are you going to provide an accounting to the charity? You know, be specific in what you're planning. It can't just be donate your points, you know, donate your points and this will happen. So you want to be specific there so there's no confusion or potential allegations of deception. Another thing we see increasingly is these more complex experiences or buzz activations where people can redeem points and either get tickets to a concert or even participate in much more complex cross-platform activations that have on-the-ground and social components. So rule number one is you don't want to be the fire festival. You know, we see the picture of the famous picture of the bread and cheese that was the dinner that people attending the terrible disaster that was the fire festival, that concert that was supposed to be a deluxe island concert and ended up being cheese sandwiches and emergency tents on a Bahamian island in the middle of nowhere one weekend. You know, you want to make sure that to the extent that you're working with third parties, you have clear agreements. You know, you've created adequate crowd controls, you've provided for safety, you've trained your staff, you know, you've addressed any local licensing considerations, you know, you've vetted your co-sponsors. A badly planned activation can result in litigation, so planning is important. Additionally, there are issues like intellectual property. When you are, when we someday get to participate in activations on the ground, you know, there are issues like right of publicity, or even for online activations. You know, if you're asking people to submit content, there are issues like people submitting pictures talking about the program or a product. Do they have the rights to feature all the people in the pictures? What about third parties in the background? Some states have an exception for people in the background who appear only, you know, in tiny, you know, who are not featured. Some states do not. What about trademark and copyright with the store signs, music in the background? What about landlord owner rights, again, for those store signs in the backgrounds, or if you're going on another person's property, and those on the ground activations. So it's important to consider with these more complicated experiences that you may be offering as part of your program, you know, the sort of multitude of myriad of considerations that may be involved and cover for them all, both in the terms and conditions that you present to the potential participants, and in the sort of scaffolding that you build to support that experience in the background, with your partners and the like. So, of course, as part of a lot of these programs and these activations, you may be using influencers like our friend Lewis here, who looks like he had a lot of fun. It's important to consider the FTC's endorsements and testimonials rule, as it may be triggered by loyalty programs. Of course, material connections under this rule that might affect credibility must be disclosed. So payment or other compensation, employment, business, or family connections all must be disclosed. So in this case, in particular, loyalty points are other compensation, even something with minimal value, or like sweepstakes entries or 50,000 points or something like that must be disclosed according to the FTC. So the FTC has been very active enforcing lately. They're also reviewing the guide for an update with public comments due June 22nd, having extended that after their initial announcement. So in this case, a disclosure to the extent that somebody received points, whether it's hashtag ad, thanks for the points, Marriott, hashtag brand ambassador, but you have to disclose whether it's the receipt of points, hashtag sweepstakes, if somebody has been asked to post as part of an entry to a sweepstakes, or, your influencers, to the extent that you are using influencers or members to promote your loyalty program, you need to make sure that they are posting if they have received something of value in order to make sure you're complying with that rule. So now we get into privacy. This has become, this is sort of one of the newer hot areas when it comes to loyalty programs. Of course, loyalty programs are one of the key ways to collect personal information from participants. And so it's important to consider that as you design your program and as you evolve it, and specific programs within your program. So, of course, what's being disclosed in your privacy terms. Are you disclosing aggregation, shares of sales, and marketing data, that sort of thing? It's important to be specific there. But then it's also lately, of course, the EU General Data Protection Regulation. Hopefully we're all up to date on that, but it has strict requirements for the processing of personal data. And in the global marketplace, that certainly can affect information collected as part of loyalty programs. And so you need to be thinking in the design and the continued evolution of your loyalty program about the GDPR. In addition, California, of course, has been implementing the CCPA, the California Consumer Privacy Act, and other state laws have been developing their own versions. So we'll talk about that on the next slide. In different industries, there are also a few laws to consider. In particular, in the supermarket industry, there are a couple of laws. California has the Supermarket Club Card Disclosure Act, and Illinois has a similar law as well. So important to keep that in mind if you're operating in that industry. And those restrict disclosing the identity or purchases of Shoppers Club, Discount Club numbers. In California, actually, you're restricted from requesting driver's license numbers or social security numbers, or sharing personal customer information. So with respect to the CCPA, this, of course, was sweeping and very controversial legislation that was operative on January 1st, 2020. Enforcement is scheduled to begin July 1st. Grants various rights with regard to consumers' personal information, but in particular with respect to the loyalty programs, it's got some specific provisions that they have a non-discrimination provision that raises some issues. So the non-discrimination provision says that you cannot discriminate against customers for our consumers from exercising any rights provided, including by denying goods or services to customers, charging different prices or rates for goods or services, including through the use of discounts or other benefits, or imposing penalties, providing a different level or quality of services to customers, or suggesting that consumers will receive a different price or rate for goods or services, or a different level or quality of goods or services. So of course, you know, you're prohibited from discriminating against a consumer because you've exercised a CCPA right, including the right to ask that your personal information be deleted. So the question is, how does that non-discrimination provision interact with loyalty programs that require personal information to operate and administer rewards? The proposed regulations clarify that denying a request to know or delete or opt out of the sale of personal information for a reason permitted by the law is not considered discriminatory. There's two examples that illustrate it. The first one involves a clothing business that's offered a loyalty program where consumers receive a $5 off coupon to their email address after spending $100. The consumers submitted a request to delete all of their personal information, but asked the business to continue in the loyalty program. This example says the business can deny their request to delete as to their email address and the amount the consumer has spent, because that information is necessary to provide the loyalty program. Sort of one example. The second one involves an online bookseller that's collecting information about consumers, including their email addresses, and offers discounts to consumers through browser pop-up windows that while the consumer uses the bookseller's website. The consumer submits a request to delete all of their personal information, including their email address and their browsing and purchasing history, and the bookseller complies with the request but stops providing the periodic coupons to the reseller. The bookseller's failure, according to the example, to provide the coupons is discriminatory. The bookseller may not deny the consumer's request to delete as to the email address because the email address is not necessary to provide the coupons or aligned with the expectations of the consumer. So these examples are making it clear that providing a loyalty program that responds to the request as required by law does not infringe on the non-discriminatory right. Essentially, the business can deny requests to delete that would interfere with the ability to provide the loyalty program, assuming the personal information is necessary to administer the program and the consumer wishes to continue receiving those benefits. You know, if the consumer insists on deletion of the personal information and does not wish to continue, then that's another matter. There's another provision another matter relating to financial incentives where you can offer financial incentives for the collection, sale, or deletion of personal information. And you can only offer that financial incentive if it's reasonably related to the value provided to the consumer via the consumer's data. It's a little muckier and frankly needs some development. You are required to provide a notice regarding such financial incentives if you're offering them. That essentially is a summary of the financial incentive, a description of its material terms, how you can opt in, how you can withdraw, and how to exercise that right, and an explanation of how it's reasonably related to the value of the data, including a good faith estimate of the value of the consumer's data. And that's really where people are getting hung up. But the question also is whether the rewards you're offering are, related to, a financial incentive intended to motivate participants to join your loyalty program, or instead you're sort of rewarding people for, and I'm maybe bogging down a little bit, but to motivate people to allow you to process your personal information, or an incentive to join the loyalty program. So still mucky, still developing, not a lot of guidance on that side of things, and we'll continue to sort of work on that part. It's clear, though, you need to provide some sort of explanation of that. So CAN-SPAM and TCPA. It's important to follow marketing laws like the CAN-SPAM and the TCPA. There are several. TCPA has kind of become a hot area for litigation with respect to loyalty programs. You need to make sure that to the extent you want to text your loyalty program members, that you're obtaining express written consent to do that. There are several companies that have gotten in trouble for this. It has to be specific to the texting, not a general sort of permission to market to them or that sort of thing. So keep that in mind. With regard to refer a friend emails, that's another area where there's sometimes some confusion. Refer a friend emails and incentivizing them with additional rewards points may trigger CAN-SPAM requirements. To the extent you're doing that, you are going to need to both sort of send CAN-SPAM compliant emails with the unsubscribe option and that sort of thing, and scrub them against your internal do not email. Additionally, take into account the platform terms of service to the extent that you're not supposed to incentivize certain programs on Facebook, where you're not supposed to incentivize sort of sharing to somebody else's personal page and the like. So you need to take that into account. Another thing, under the Robinson-Patman Act, offering a richer program to one promotional program to one retailer versus another could be discriminatory. So that's under Section 2D and 2E. There was a recent lawsuit in this area that alleged that a paint finishing supplier used its loyalty program to provide discounts that unreasonably restrained trade. So it's important to keep in mind, don't offer better loyalty programs to one customer than another. Additionally, Section 2C prohibits commercial bribery, and many states have similar provisions. So to the extent that you're offering rewards programs to the employees of your customers as part of a trade promotion, you want to be aware of these laws. Generally, you can address them by getting the consent of the employer to include employees of the programs, either explicitly or at least through representations in the terms that the employees will get their employer's consent. Often low value gifts under, $100 or the like are excluded, so that's another thing to take into account. Employee loyalty programs. To the extent that you are involved in providing loyalty programs specifically targeting employees, there are some other considerations. Specifically, what should be included in the regular rate of pay under the Fair Labor Standards Act and the states that follow it. Certain types of loyalty programs should be included, and this is with respect to hourly employees, which includes all remuneration for employment, subject to some exceptions, like discretionary bonuses, gifts, holiday bonuses, other bonuses for special occasions, that sort of thing. But performance bonuses or points awarded if you, work 2,500 hours in a year. I don't know anybody who does that, but generally they're not hourly. Those are not included in the regular rate of pay. Additionally, in California and some other states, points may qualify as wages expressly. California actually expressly prohibits the use of scripts, coupons, or cards or other redeemable things as payment or wages. So that is actually potentially something that may be interpreted to bar the use of employee loyalty programs. The other thing is that if points are wages, then expiring points may be viewed as a forfeiture of wages. This is all stuff that's sort of in a grayer zone, but it's something that is very fact-based in terms of whether it should be expired. But generally, as sort of a rule of thumb, you should only try to expire points if they've been given as discretionary bonuses or gifts. Another interesting area that's been addressed lately is this issue of human rights laws or the Americans with Disabilities Act. I think we've all seen lawsuits now addressing, or maybe even received a letter about, oh, your website isn't ADA compliant. But there have been a few lawsuits involving whether your loyalty program is ADA compliant. One plaintiff sued the Container Store, alleging their loyalty program discriminated against the blind because their in-store electronic device could not independently be used by blind customers. There have also been a few suits against companies issuing gift cards because they weren't in Braille, or they didn't have Braille gift cards. There have also been a number of lawsuits over the years challenging various promotions based on discrimination on the basis of gender. We've seen complaints to attorneys general based on age discrimination. So it's important to keep in mind that sort of characteristic in structuring your various programs. A note on partnerships and third-party agreements. Of course, often partnerships are increasingly a characteristic, or almost necessarily a characteristic, of loyalty programs, whether it's your suppliers or these experiences or the like. A few notes: it's important to be clear about the roles or the requirements, but also you want to do things like get representations and warranties about compliance, indemnification clauses to back that up. If you're working with a particularly small company, hopefully you can get some insurance to back that up, and make sure that it's the right kind of insurance, in terms of advertising or if it's an experience, the right kind of liability insurance, that sort of thing. Remember that the FTC, under the substantial assistance doctrine, will try to hold all parties liable for consumer protection violations, including, in some cases, individuals. In one recent influencer case, the FTC pursued the owner of a company in addition to the company and the influencers when the owner posted reviews of the company's products. So that's not substantial assistance, that's direct liability, but it's important to remember that everybody may ultimately be pursued if there's been consumer protection violations. In addition, with privacy, the CCPA defines what a sale is very broadly. In particular, some of your fulfillment companies, what may be viewed as the transfer of data may actually be viewed as a sale, where it might not otherwise have previously been. So you want to look at that closely. And you also want to just, of course, look very closely at whether your partners are compliant from a privacy perspective. We've also talked about force majeure and COVID-19, and of course that's more important than ever to look at whether those force majeure clauses will cover, illness, pandemic, well, really epidemic, because you don't want to have to wait for the WHO to declare a pandemic. So wrapping up, of course, there's been an upswing in litigation involving loyalty programs as their popularity has increased. As we talked about, courts are less inclined than they once were to evaluate solely on contract terms. And of course, the theories of the case are increasingly creative. We're also seeing state and federal enforcers get into the action. If I could say anything, make sure that your advertising is consistent with your terms and conditions, and to make sure your key terms are clearly and conspicuously disclosed. And consider the effect of new technologies, keeping an eye on how the law is developing when it comes to things like digital consent, virtual currency, and anti-money laundering, charitable promotions, and unclaimed property are all very hot areas. They can help you, particularly with things like digital consent. Finally, keep an eye on how COVID-19 is developing, particularly with respect to things like, what it means for the ability to provide rewards. Make sure you're covered on that front. Take a look at your terms and whether you are covered, both from the point of view of your modification provision, your force majeure provision, and specific provisions as to experiences in travel and the like. So we have just a couple of minutes to look at questions. Let's see. Would most of this information to be irrelevant to businesses offering loyalty and rewards programs to businesses versus consumer? It's my understanding that, okay, so I think in terms of businesses offering loyalty and rewards programs to businesses versus consumers, of course, you have just sheer contract issues. B, the Robinson-Patman Act and this issue of discrimination is and antitrust is directly relevant. And also it's going to depend on what the businesses are also doing. It's sort of hard to make a broad analysis on businesses, but a lot of what we just discussed, sweepstakes will apply. A lot of what we just discussed, influencers will apply. Lots of this will apply to businesses. It's my understanding that points cannot typically be donated to a charity for a tax deduction unless they have been purchased. Is that correct? I will have to get back to you on that one after consulting with my tax friends. Do we have any other questions? Double check back in our Q&A. I am, of course, available for further questions if you want to email this. Email them to me. Oh, do we have a second code? All right, I believe that is it. So thank you very much. We're 3 o'clock on the dot. Thank you for helping me be timely. And thank you for listening.